Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to class number 10 of our 2025 virtual HOA and Condo Academy. Today is Tuesday, October 21st, 2025. And our topic for today is navigating assessments and large capital improvement projects. For those of you who are just joining us, welcome. I'm going to give a few seconds for attendees to either enter the Zoom and get settled here or to join us on Facebook Live. Welcome to class number 10 of our 2025 virtual HOA and Condo Academy. We teach these classes in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and the city of Tempe. My name is Beth Mulcahy, and I am the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have now for over 14 years. In this class, we will explore whether associations should increase their assessments, the regular assessments, and by how much, and what legal authority they have to increase those assessments. We're also going to talk a little bit about special assessments and managing large capital improvement projects and how you can best manage capital improvement projects in your association. And honestly, this is a great time of the year to be teaching this class because many of you are working on your budgets right now for 2026. And you're probably considering whether or not you want to do an increase in your assessments or maybe even have a special large capital improvement project in your association this year and how you might be able to fund that. Okay, moving right along, we're going to address questions, of course, like we always do at the end of the class. So if you have questions, we're probably going to be concluding the main presentation a little bit before noon today, and we'll move right into the questions at that time. Due to the large volume of attendees, what we typically will do is ask that it's only one question per attendee. And please, if you're giving us a question, please make it as short as possible and to the point and not association specific using like your association's name, etc. If you're joining us on Zoom, please submit your questions in the Q&A box. And if you're joining us on Facebook Live, please type your question in the comments section. Okay, let's move right along. We're going to be doing a poll to start out this class today, just so we can determine how many of you are here today. So before we start the seminar, I'd like to get a feel for who our audience is so I can best tailor the class here today. First question is, in which city do you reside? So if you're joining us on Facebook Live, please put the city where your HOA or condo is located in Arizona. The second poll question is, let us know your current role with the association. We're interested in that so that we can tailor the class to best suit the needs of who's attending here today. While we're waiting for those poll results, we're going to go ahead and talk a little bit about the Arizona legislature. And we've been talking about the 2025 Arizona legislature since the beginning of January. Now we're 10 months into our year, and we had 4 bills that directly impact associations that were passed this year. And all those bills went into effect on September 26th. It was a pretty active year this year in the legislature. There were a lot of bills introduced, but fortunately, we only ended up with 4 new ones to further regulate associations. So here is just a very quick summary of the new laws impacting HOAs and condos. And again, these laws have already gone into effect on September 26, 2025. So the first bill is Senate Bill 1039. This bill applies to both planned communities and to condominiums. And the impact of this bill is, it talks about recording of board meetings. And so I would say most of our clients now are conducting Zoom meetings for their board meetings. And so there's a feature on Zoom where you can click record meetings. And so I think this is kind of a sign of the times law in that there are pretty frequently now recordings of board meetings. And prior to COVID, not a lot of our clients had recording systems and they weren't using Zoom, and it was kind of cumbersome to record a board meeting, but now it's pretty commonplace because virtual meetings are kind of taking over. So basically what this law says is that boards must keep recordings of an open meeting for 6 months. And if an owner wants to see a copy of that recording of the meeting, that they are entitled to receive an unedited copy of the recording of that meeting. This bill does not say that planned communities and condominiums must record their board meetings. It just says if you do, you have to keep it for 6 months. and that if an owner wants to see an unedited version of the meeting, you have to provide it to them. Okay, the next bill is Senate Bill 1378. This also applies to both planned communities and to condominiums, and this talks about flags that are used, political flags in a community. So another sign of the times bill, frankly, after the last two presidential elections. Basically, what this bill says is that political sign definition is included political flags that are being flown. And so, kind of the impact of this is if you live in a planned community or a condominium and you have an owner that wants to fly a political flag, it's going to be subject to the same rules as political signs would be in your community. And there's a state law already on the political signs. So, it can only be a certain size and you can only fly it a certain number of days before the primary, and it has to be down a certain number of days after the election. And again, that bill went into effect on September 26th. And with the general election, we've got another election and some propositions that are going to be voted on here in the next 3 weeks, 4 weeks. That may be something that you'll want to keep an eye on. Okay, the next bill is Senate Bill 1494. This bill only applies to planned communities, so condominiums, this does not apply to you. And this just kind of changes the threshold for when we're able to foreclose. It makes it a little bit more difficult for us to foreclose if you're a planned community. So basically what the law change is that we have to hit a certain benchmark before we can foreclose on an owner for not paying their assessments. And that benchmark was changed from 12 months to 18 months, or it used to be $1,200 in delinquency. Now it's $10,000 in a delinquency. So the practical implication of this bill is it's more difficult for planned communities to foreclose. It's not significantly more difficult because, it's you only have to wait an extra 6 months, basically, which is probably where most of us are going to, this bill is going to impact us the most. So if you're a planned community and you're looking at this new bill and how it might affect your association, if you have an owner who hasn't paid assessments for 18 months, you can foreclose. It's an or, so it's either 18 months or they owe 10 grand. Let's be real here. Not a lot of planned communities have assessments that are that high a dollar amount. So to get to 10 grand is going to be like really difficult. And so it's either or. So whatever occurs first. So if they haven't paid their assessments for 18 months, we can now foreclose on that assessment lien or $10,000 delinquency. Okay, the last new law that impacts HOAs and condos is going to be House Bill 2322. And this particular law, it really just impacts condominiums only, and it really kind of just gives us some additional information about commercial condominiums, so like office condos, and helps with some definitions pertaining to that. Not a lot of associations actually are going to be dealing with that particular law because we don't have that many commercial condominium associations in Arizona. Okay, let's go back to our poll results. So we have our poll results in, and in which city do you reside? We have 1% today from Avondale. We have 8% from Chandler, 3% from Glendale, 4% from Goodyear, 24% from Mesa. Wow, that's really good representation. 7% from Peoria, 19% from Phoenix, 19% from Scottsdale. So awesome. 2 more great cities with great representation today. 8% from Surprise, 8% from Tempe. And so that's amazing. So we have every city that is putting on these classes in conjunction with their firm is represented here today. So that's amazing. The next question is, what is your current role? So we have 60% of you are on the board. We have 11% that are managers, 25% that are interested homeowners, and then other 4. And really interesting, we have over 155 people here on Zoom and Facebook Live today. So that's a really great turnout. So happy to see so many people here today caring about your communities and wanting to learn more about assessments and large capital improvement projects. Okay, just briefly going to go back and talk about just a couple other things that I think on the new legislation that are important for us to know about this year's legislature. The small claims court limit was raised to $5,000. There are some new procedures for county tax deed land sales, and HOAs may buy their common area property back. They lose it. It's kind of a weird one. There's some new construction hours. There's a bill and also some new accessory dwelling laws. But on both of those bills that talk about municipality regulations, associations can be more stringent or pass rules or have something in their documents that talks about construction hours and when you can start construction and when you can end them. and also accessory dwelling units. If you have something in your documents that's more strict than what the new law says, we can, and most of our clients do have that. Our documents still control here. And then the last thing is, if you're getting ready to file your annual report this year for your association with the Arizona Corporation Commission, don't forget every year you have to file your annual report to keep your corporate status. Why do we do this? So that we don't have personal liability for all the members in the association. So really important that everybody file their annual report every year. Unfortunately, they're not all due January 1st. I wish we had just a set date that they were due by. You have to check what your due date is for your association. It usually depends on when you were incorporated. So it's throughout the year they're due. Anyways, when you're filing your annual report now in Arizona, you have to have 2 forms of ID are required for the filings. So very interesting corporations, will have to submit a custom annual report with these 2 forms of ID. So it's just going to make it a little more difficult for the management company or the board members to file their annual reports. If you need help with it, our firm is here ready, willing, and able to help you through that process. Okay, let's pop right into our main presentation today. We're going to be talking about assessments and how to best manage large capital improvement projects. So just as a starting point, like I said a little earlier in this presentation, this topic is a great topic for this time of the year because many of you, myself included, on the 2 boards that I'm currently on, we're getting together what our budget is going to be for 2026. And so we're running the numbers, we're determining how much of an increase we have to have in our assessments to pay our just normal bills. And then in one particular association, or actually 2, we're talking about large capital improvements on the master and the sub-association board that I'm a board member for. And so this is a really relevant topic for a lot of associations because usually September, October, November, and to some extent December are planning times for your 2020 boards and associations. And so we have to anticipate how much money we're going to need to pay all our bills in 2026. And we have to anticipate how much money we're going to need in case we want to do any large projects to maybe redo a pool or repave your association's roads or something like that. So in this session, this is a really hot topic for this time of the year. So hopefully the information that we provide to you today can really help you as you're putting your budget together for 2026. Don't forget, we have 2 great cheat sheets that kind of go hand in hand with this presentation today. One is on budget preparation, and you can find those cheat sheets on our website at mulcahylawfirm.com. So if your association is struggling right now on putting your budget together, would be a great idea to go get that cheat sheet off of our website and take a look at it because it gives you just from A to Z how to start a budget and finish it. If anybody here wants a sample budget in an Excel spreadsheet, I also can provide that to you as well. Just so you can kind of see how we set it up in the sample budget for an association. Another really great cheat sheet that might be helpful for you today would be the one that we have on reserve studies, especially as we look at large capital improvement projects. And so I encourage you to take a look at both of those cheat sheets if you are so inclined. Okay, let's talk a little bit about what's the difference between a regular assessment and a special assessment. And let's just make this as easy as possible to understand. So a regular assessment is the reoccurring dues or fee that's set in the annual budget, and it's paid per owner to fund routine operations in your association. Every association has on their financials just regular bills that they have to pay, like landscaping, insurance, management company fees, legal fees, utilities for common areas. Maybe they make a reserve contribution every year off of their general income that they have coming into the association. So typically a regular assessment is going to be billed monthly, quarterly, annually, pursuant to the governing documents. Most of our clients are doing monthly billing of the regular assessment. So again, just to kind of close the loop, regular assessments are reoccurring. It's usually they're set up in the CC&Rs, which we're going to talk about in a minute. And you set it in the budget each year. And usually the budgets have like a formula sheet where it takes like maybe you need $1 million to run your association and you have 100 owners. And the Excel spreadsheet formula will divide what you need by 100 owners, and then they'll divide it by 12 for 12 monthly installments. Okay, special assessments. This is a little different. This is a one-time charge or a limited term charge in addition to the regular assessment to fund a specific shortfall or a project. So, for example, if you're a condominium and you need to have your roofs replaced, or you're a condominium and you need to have a new chiller put in, or you're a planned community and you want to redo your clubhouse, these would be a special assessment is typically how sometimes this is funded in an association. It also could be for an emergency for your association, like an emergency repair. Or unfortunately, sometimes we've seen a special assessment to pay for a lawsuit judgment. Not very often, but occasionally we will see that if there's not enough funds in the association to pay for a judgment that may be entered against them and there's not enough insurance. Typically, the special assessment is tied to a defined purpose, and it's usually defined in the CC&R. So what does that mean? The special assessment, there'll be a section in your CC&Rs that will say an association's board can levy a special assessment for the purpose of maybe funding the reserve, or for the purpose of a long-term capital improvement project that needs to be done in your community, or an emergency funds that are needed. So typically it is defined in the CC&Rs, and it will usually also indicate how that can be done. Sometimes an association CC&Rs, the board is allowed to levy a special assessment without a vote of the membership. But more often than not, you need a percentage vote of the homeowners to levy a special assessment in your community. And we're going to go more in depth on that in a minute, but oftentimes there may be a payment schedule that's offered to the owners if it's a large dollar amount, whereby like if it's $20,000 or something really large, maybe they'll let people pay it off over 20 months, $1,000 a month or whatever. And that's something that the board just sets up initially in the planning process for the special assessment. Okay, what are the differences between a regular assessment and a special assessment? Really, the purpose is different. So regular assessments are going to be for ongoing operations, and reserves typically are for something specific or a shortfall that they may not have enough money for something and they need to have a special assessment for it. So typically the purposes are different for both. The duration is different too. Like it's a regular assessment is ongoing. A special assessment is usually like a one-time thing, or maybe it's just over a year or 2 years that you pay a special assessment for something. Also, some key differences are that to increase the assessment, the regular assessment may have a different requirement in your documents or by state law versus the special assessment. So I wish we could just say that everything, you can increase the special assessment, a certain way, and it's the same way for the increasing the regular assessment, but that's usually not how it works. Usually you really have to be dialed into what your documents say and what state law says to know how you can increase the assessment or the special assessment. Okay, where does the power to levy these amounts come from? So typically it's going to be from your governing documents, and it's 99.99% of the time going to be in your CC&Rs. And that's where there's usually a special section in your CC&Rs that talks about regular assessments, how they can be increased with or without a vote of the membership. And everybody's documents are a little bit different. So I wish I could just give you a bright line rule and say this is the rule, but every document is going to be a little different. And the same thing for special assessments. Every document is going to lay out how to do a special assessment. Occasionally, we'll see associations documents that don't even envision having a special assessment, which is unfortunate. That's something that every association really needs to have in case they get in a pinch and don't have enough money to pay for an emergency or a large capital improvement project out of their general assessment fund. There's also some legal authority in Arizona law that talks about some limits that are placed on boards if your documents don't have, a limit in terms of how much you can increase your assessment rate, et cetera. And we're going to talk about those in a few minutes. Kind of a really important thing to think about if you are planning your budget and you're thinking about an increase in assessments, regular assessments, or a special assessment this year and coming year in 2026, you really need to think about, are we a condominium or are we a planned community? Because there are some nuances in the law that make the requirements a little bit different for condominiums versus planned communities if you're thinking about increasing your regular assessment or if you're thinking about levying a special assessment. So remember, always know, especially if you're a townhome, because it's kind of confusing in Arizona, townhomes are not legally recognized, which is just a weird nuance, but it is what it is. So if you're a townhome, you're either a condo or a planned community. Townhomes are not legally, even though your documents may call you a townhome, they're not legally recognized in Arizona. if you're at this juncture, sometimes it's really easy. Like you look at your documents and it just says ABC Condominium Association. So most likely you are a condominium, right? Or maybe you say ABC Homeowners Association. It's usually going to be a planned community. But if you want to know the difference as to, from a legal perspective, as to whether you're a planned community or a condominium, the legal difference is really who owns the common areas is the first thing that I look at. If the association owns the common areas, you're traditionally going to be a planned community. If the owners in the condominium, let's say there's 100 owners in the condominium and they own a percentage interest in the common areas through their deed, then you're typically going to be a condominium. Okay, let's move right along. And let's talk a little bit about how to increase your regular assessment. So if you're looking at your budget right now and you've got your total dollar amount that you think you need in income, and you're looking at ways to fund it, you may be looking at, okay, how do we raise our regular assessment to meet our expenses for 2026? So if you're a planned community, the analysis is going to be a little different for planned communities versus condominiums. So if you're looking to raise your regular assessment and you're a planned community, first, you're going to be drafting your budget, right, for the next fiscal year, and you're going to have your operating budget, right? And then you're going to have how much money you need in your reserves. Hopefully, you have a reserve account. So the first step is, okay, come up with the numbers that you need for 2026. So what are our expenses, or what do we anticipate our expenses will be? And look at our cheat sheet on budget preparation. It'll be helpful for you as you navigate that process. The next thing you want to do is check the documents, right? Do the documents give you any sort of direction as to how much the board can increase the assessment rate in a planned community? So we really see all different kinds of language in CC&Rs. Kind of a common thing that we would see is that the board can increase it up to 10% without a vote of the membership. And then anything over 10%, the board would need to get like 51% or 67% of the membership to approve it. And so we want to look at your documents. That's a common one. Also, sometimes we'll see in older documents that were written like in the 90s, 80s, 70s, we'll see they tie in the assessment increase with whatever the consumer price index is. And that's going to be, a small percentage, smaller than 10% for sure. And there's consumer price index calculators that you can find online to help you navigate that, how much you can increase it. So the key thing is if you're a planned community, you're going to want to check your documents to see what your documents say about how much you can increase the assessment rate per owner without getting a vote of the membership. So the board's going to have to look at that. And honestly, being on my board myself for many years, we really do think about that as we're creating the budget, because the reality of the situation is that when we're creating the budget, we know we're going to have to face our owners, like our annual meetings in December. And if we have a large increase, we're going to hear about it. And so we're trying to balance not having the assessment rate be so high that people who are looking to buy in our association won't want to live here and will maybe go to the association down the street where the assessment rate is a little bit lower. Also, we're balancing, are people going to be really upset about this, right? Like, is it an 8% increase? Is that too much? Are people going to say, hey, that's not keeping up with inflation? That's much higher with the actual needs we have. Like the reality is our insurance bills are going up, our electric bills, our utilities, our trash services, all these expenses are going up. Our management company fees are going up each year, and we can't not raise it. Otherwise, we start going into a deficit situation, which we don't want. Just as a reminder, as planned community, check your documents to see what it says about increasing the regular assessment. That's the first stop. If your documents are silent or on increasing the assessment, or maybe it doesn't even have any cap on it, maybe it says something like the board can increase it for whatever the needs are, well, then there's a state law that kicks in and says that if the proposed regular assessment is greater than 20% above the prior fiscal year's regular assessment, they're going to need to get 51% membership approval in order to do that. So the only time we would look at that state law, again, is if your documents are silent on how to increase the regular assessment, or maybe it gives the board the authority to, or all kinds of authority, no cap on how much they can increase it. Then the state law is going to kick in and put a ceiling on that. Be like, wait a minute here. You can only increase it above 20% above the prior fiscal year's assessment with a membership approval by 51% of your members. And so that's kind of an important little distinction for everybody to think about as you're planning your budget. remember that if you are doing an increase from in a planned community, a very practical suggestion here would be talk about the budget in an open board meeting. You may not have a lot of people coming, but at least there'll be minutes showing that you were talking about this and why there's a need for the increase. Also, when you notify the owners, maybe you're sending out a communication or a newsletter, or you're putting something up on your website, explain it really well. This is why we need an increase in our assessment rate, and, show them the budget, give them an opportunity to look at the budget. And I think if you have good communication, most people understand that each year things get more expensive, right? And so there shouldn't be a lot of pushback. What I found people really don't like is when you don't raise it for 8 years, don't do any increase in your assessment rate, and then year 9, you're trying to raise it by like 40% or something. So that's a very big differential for people in their own personal budgets. So it's much better, in my opinion, and much more fiscally sound to be doing a small increase every year based upon what the increases are that your vendors are giving you, or the different services that you're providing to your association members. Okay, let's talk a little bit about condominiums. It's a little different analysis for same but different. So in a condominium, you're going to do the same process. You're going to be doing your budget, just like we talked about for a planned community. But there's a little bit different process in condominiums. Some condominiums have a requirement that they have to have the owners approve the budget. And so you got to look at your documents to see if your documents require that. And if that is the case, then you have to provide the budget to the owners within a certain timeline. And then there's a meeting. It's just a regular board meeting. And if the owners that come to the regular board meeting, if more people are opposed to passing the budget than are in favor of it, then we may have to go back to the drawing board and create a new budget and notify the owners of the new budget and do the same thing again, have another meeting, a regular meeting of the board. And if people come to the meeting and they say, we don't like this increase, and there's more people that don't like the increase than people that are in favor of the increase, then you may have to go back to the drawing board a couple times. Now, the practical reality of this is that hardly any people come to the board meetings. Okay. So even when you're talking about the budget, unless there's like some really big hot topic that, is pertaining to the budget, most people are not coming to the board meetings if you're in a condo. So the practical reality is the fact that there likely will not be people that are opposed to the budget, or there are likely people that don't even know they have the right to be opposed to the budget. So it just doesn't come up in practical reality of being in a condominium board. So let's go back to condominiums, and remember that when you're creating your budget, you want to look at your CC&Rs to see how, regular assessments can be increased. Typically, it's very specific as to how the increase can be handled by the board. It's usually like the consumer price index. It could be a percentage like 10 or 15 or 20%. The interesting thing about condominiums versus planned communities is we don't have that law, that's that 20% law that we talked about a minute ago with planned communities. So there is really no cap on how much the board can increase the assessment in a condominium other than what's listed in your documents. So if your documents don't have a cap, there's no state law to put a ceiling on how high your board can increase the assessment. But again, same process for condominiums. Just have good communication with your owners, be very upfront with them about why we need to increase the assessment. And smaller increases each year are better than having a big increase, at the end of 8 years with no increases. Okay. Some best practices just to go over for you as you're navigating levying your regular assessments and increasing your assessments each year as part of your budgeting process. I think it's really helpful to use an assessment calculator showing, okay, this is how much the dues were before, and this is how much they are now, and here's what percentage it increased, and then where the money is going to go. Like, why do we need to have the increase? Just good communication with your owners, I think, will kind of quiet people down. If you don't communicate with your owners and tell them this information, and they get the new coupon book at the beginning of January 2000, at the end of December 2025, and they see that their assessment rate jumped from, 100 to 260, you're going to pay for it. People are going to be upset and come to a board meeting and be screaming and yelling. So if you are going to have an increase that is going to be any increase, really, you should be doing this. But especially if you're having a big increase, you may even want to consider having like a town hall meeting to discuss this so that people are aware of the need and why we're doing this. so that there's not as much pushback when they actually have to start writing their regular assessment checks on a monthly basis or a quarterly basis to your association. Okay, let's switch gears and talk a little bit about special assessments and how to levy one. Like, what's the process for a special assessment? The first thing on a special assessment is, we're going to have to really think about what's the need? Like, why do we need a special assessment? So, is it an emergency repair? Is it a capital improvement project? Like, we're going to redo the clubhouse, redo the pool, redo the children's park area in your association, the roofs if you're in a condominium. These are all pretty common needs that a planned community or condominium association would have. Sometimes we're also trying to fund the reserves. So let's say that the reserve account, just refresher, is kind of like a savings account for long-term capital improvement projects in your association. And ideally, you should be putting money in your savings account every month pursuant to a reserve study that's been done by a professional company telling us, okay, these are all the assets you have for your community. And it tells us what the useful life is for them. And maybe the pool's useful life is up in 5 years. So we should be saving every year between now and 5 years so that at the end of the 5 years, we have the money in our reserve to pay for the pool resurfacing or repaving or plastering or whatever the issue is. So first thing we want to do is identify what's the need here. What's the need that needs the big money? Okay, then we're going to need to define the scope and the cost. So we're going to need to obtain bids, try to get bids from 3 different vendors. They should be licensed, bonded, insured vendors. Please do not use unlicensed vendors when you're doing a large capital improvement project. You may have to bring in experts like an engineer to help you with something. You also may want to set a contingency. I know my association right now is doing a special assessment to do some major capital improvements to our common areas. And we factored in like a 20% contingency for things that can go wrong or problems. And honestly, I'm really glad we did because we just had a little problem that came up about a month ago that is going to be a $50,000 problem. And as we started to do the work, and we're really happy we have that contingency built into the special assessment. So all things to think about as you're defining the scope and cost of whatever the special assessments can be used for. Next thing you're going to want to do if you're thinking about levying a special assessment is, where do you get the legal authority to do this? So you're going to want to check your CC&Rs and look to see what purpose we can levy a special assessment for. Can the board do it? Likely no alone, but usually there's a process. Like the board has to make a motion to approve this at a meeting and then send it to the membership for a vote. So it will be discussed by the board. Hey, we have a need to redo the pool. And we've gotten the bids and we've had experts come in and provide us with advice regarding what type of pool changes we're going to be making. And now we have the 3 bids from licensed and bonded contractors. But we need to fund it now. So the board is hereby proposing to move forward with a vote to levy a special assessment. Okay. And what you're going to want to do is look at the documents, like what membership vote is required to levy a special assessment. Because like I said, 99.99% of the time, we need members to vote to approve the special assessment. And usually it's going to be like 51% or maybe 67% of those who attend a meeting for this purpose. And the quorum for that meeting may need to be 60%. This is where you definitely want to think about getting your legal counsel involved if it's kind of confusing in the CC&Rs or the declaration as to, okay, what's the purpose? Does this meet the purpose that's defined in the CC&Rs? And then what percentage do we need? You may just want to talk it through with your attorney and make sure that you're reading it correctly so that you're stating properly what the percentage is that we need. And then typically you're going to just go through the whole process of getting the vote. So maybe you do it in conjunction with an annual meeting. Maybe you have a special meeting of the membership just for this purpose, but you're going to have to notice the meeting pursuant to what your documents state and state law. You're going to have to send out ballots. Some of you are still doing paper ballots. Probably a majority of you are still doing paper ballots, but many of you are now converting to using like online voting systems, which is amazing. It's kind of the future of our industry. And so you're going to come up with balloting procedures, and then you're going to actually have the meeting where we're going to have a quorum of the members there. And then you're going to have to look at what your documents say to have the quorum. And then you're going to count the ballots at the meeting and see if you've got the percentage that you need. And so it's really a good idea. This is a little more complicated than a normal situation where the board just can approve something. When you have to get a membership approval, this is really where you need to dial in and get your attorney involved to help you through this entire process so you do it right. Because if you have anybody who's opposed to it, they're going to be looking for problems, and, they potentially could sue if they don't want to pay it, and could really slow down the entire process with the lawsuit. This would be where I would recommend you bring in your legal counsel to help you navigate this process as you're figuring out how to move forward with the special assessment, from identifying the need to defining the scope and how much it's going to cost, to getting the membership approval at a special meeting of the membership, and then how you're going to collect the special assessment as you move forward. Okay, some important nuances that we want to think about for collection of either special assessments or increasing the regular assessment. Be reasonable on the special assessment would be one thing that I'm going to say. There are times where a board, you're collecting a special assessment and maybe somebody comes to you and says, hey, I don't have $5,000. I'm on a fixed income and I can't come up with the $5,000. It's in those situations where I think boards need to be reasonable and try to work with the owner. Say, well, what could you do? Can you pay $500 a month until it's paid off? Try to work out a payment plan. Usually, I can't think of really any times where we've had an owner come to us in 29 years and they want to pay the special assessment, but they can't do a lump sum payment. And so we work out like a little payment plan with them. I can't think of one time where somebody breached it. And so just be reasonable, recognize that these are your neighbors, and have good communication that if you can't afford to pay it all at once, we can do a payment plan with you. And it works. I mean, I've seen success stories on that with many associations that handle that. So really, that's kind of our main points on regular assessments versus special assessments. What's the procedure to levy them? When do you need a homeowner vote? A lot of this is going to be document specific, and you definitely want to be reaching out to your attorney to help you through this process, because you want to make sure you do it right so that you don't get sued by an owner. Okay, let's switch gears and talk a little bit about large capital improvement projects. So this kind of goes hand in hand with the special assessment discussion. Typically, when a board comes to me with a large capital improvement project, and like I said earlier, I'm also involved in 2 large capital improvement projects, the boards I'm on right now. There's kind of 2 ways to handle it. So there's one way would be you just do one project at a time, and maybe you do it like one big project every 2 years, or one project a year, depending on how large your association is, or one project every 5 years. One thing I can say, though, is having been in the Arizona industry since 1995, what I found most associations do is there was a large development push in Arizona between 1980 and about 1999. And a lot of these associations now are aging communities. They're 25, 35 years old. And a lot of them have done a lot of Band-Aids. And I call it caulking and walking, not really fixing the problem, but just kind of temporarily fixing it. And now they're faced with like really serious issues for an aging community that's 25 years plus old. And they have a lot of things that need to be fixed. So there's kind of 2 different ways to kind of navigate large capital improvement projects. The best way, in my opinion, would be to have a reserve study done by a licensed and qualified reserve specialist. And do that. You should already have that for your association. If you don't, I would really recommend that you look at our cheat sheet on this and consider getting a reserve study done, because that's kind of like your roadmap as to how much life each of these elements of your association has left before you have to totally replace it. For example, the reserve specialist company will come out to your association and they will do like an inventory of all the things that the association's board is responsible for maintaining. And they will look at the amenities and they'll say, okay, well, the pool only has 6 years left. And maybe the roads have 11 years left. And maybe the clubhouse is going to need a new roof in 10 years. And they put it into a formula that the company has, and then they give you a 30-year plan for your association on how you can save through your reserve account, so that when the useful life of each element is up, you have the money in your bank account, in your reserve account, to pay for it. So that's like a really good long-term planning tool. The problem in Arizona is there's no requirement under the law to have a reserve study or to have a reserve account. And so a lot of associations don't use that really great planning tool of having a reserve study to help them navigate their time on the board. I'm glad you're here in this class today so that we can talk about how important it is to have a reserve study done and to have a reserve account for your association for many reasons. It's kind of like a long-term planning tool. It also alleviates the need to have a special assessment because you're saving as you go each year. And so that's just kind of a good starting point on the large capital improvement projects. Some associations are kind of doing it the right way where they have the money in their reserve account and they are just ticking off projects each year based upon the useful life when the amenities useful life is up. Other associations are in what I would call more of a crisis mode. Unfortunately, my association that I'm on the board, both of them are in crisis mode right now. So I'm very familiar with how that rolls. And if you're in one of those crisis mode ones, it's like you don't know which amenity you should focus on first because there's so many problems, right? And so that's a very scary and frustrating place to be. But some suggestions, if you're in that place, would be you really should think about bringing in like a master plan specialist if your association has the funds to do it. And there's companies all around the country that they come in, they'll do a full evaluation of your property, and they will come up with a 10-year or 15-year plan for you on what amenities you should focus on first. And this is probably going to be for the larger master plan communities and how we can develop this over a 10 or 15-year period and have everything come together like a puzzle. So everything looks similar and so that we keep the character of the association, et cetera. And so really there's kind of two thoughts on how to do capital improvement projects. It really depends on what kind of an association you are and how you've handled maintenance and long-term capital improvements in the past. And our firm has been successful in helping associations, all different kinds of associations, ones that have the reserve and closely follow it, ones that maybe don't have a reserve funded or haven't really had a set plan. And now they're at the aging community crisis stage and they need help. Okay, so let's switch gears and talk a little bit about funding of a large capital improvement project. There are a number of ways to fund it. You can fund it out of your reserve, which is the ideal way because you're not going to have a special assessment. But if you have the money in your reserve already, pursuant to a reserve study, and you've been putting money aside for a long period of time, that's great. Good for you. Most associations they don't have enough money to pay for these long-term capital improvements or large capital improvements. And so they're doing a special assessment. They may have to get a loan from a bank to do that and pay that loan back over 10 years, 15 years, 20 years. Sometimes they do a hybrid where maybe they take a little bit from their reserve account that they've been saving and then they do a special assessment, or they do a loan, or maybe they, hybrid it three ways, have a loan and layer it like a loan for a certain amount of money. Some of the money comes out of the reserve. Some of the money is a special assessment. It really just depends. And our firm can help you if you're in this situation where you're like, hey, we don't know what's the best way to fund this. We don't want to deplete all of our reserve account, our savings account, but we're not sure if a bank will give us a loan. We can talk through all of this with you and, we'll want to check your documents to see if you can even get a loan. You have to be authorized in your documents that allows the board to take a loan for something of this nature. Most documents do allow that. Okay, so let's get into the nitty-gritty. What are some examples of a large capital improvement project in Arizona? So re-roofing is a very common problem in Arizona for condominiums, asphalt and concrete. Maybe you maintain your roads if you're a planned community, or maybe you have parking lots if you're a condominium. Plumbing and infrastructure. This is huge. Because in the 80s, a lot of this plastic PVC piping was used. A lot of that piping has broken and is causing major damage, especially in condominiums. And so converting that from the plastic piping to copper piping, which is generally, everybody agrees that the copper is going to be the best. So copper galvanized repipe relining, sometimes sewers over time start to fail and they start to settle in the ground and then causes sewer backups, which get very expensive. Also, fire life safety systems. These are very common type large capital projects in a community. Elevators. If you're in a high-rise or mid-rise condominium and you have elevators are so expensive, and that is something that you definitely have to plan for. Usually elevators last somewhere between 25 and 35 years is what we've learned in our industry. Pools and amenities, so clubhouses, pools, jacuzzis, all of these cool decks, shade structures, clubhouse refreshes, all of these are examples of large capital projects, which would be common in Arizona. Water management, especially because there's so many problems in Arizona with the not having enough water, right? Because we're in the desert, and a lot of the new requirements that and incentives that are being given to HOAs and condominiums to change to greener options, which are getting away from turf and getting more into desert landscaping. And that requires different irrigation systems. And so changing from a turf to a desert landscaping situation on your common areas, that could involve irrigation changes and also landscaping changes. Also, some things that are insurance driven. Some of you may be hearing feedback from your insurance companies that, hey, we're not going to renew your policy unless you do this, this, and this. I'd never seen that before. Maybe like 3 years ago, we never saw the insurance companies doing that. But now insurance companies are sending an inspector out to associations, typically condominiums, and they're saying, unless you do this, fireproofing, unless you change the stairwells, the spindles and the stairwells aren't to code or whatever, we're not going to renew your policy. So sometimes that results in us having to have a large capital project in your association. So those are just some good examples of, okay, here are the different types of large capital projects that we typically will see in Arizona. Okay, so let's talk a little bit about how to move forward. So what is our fiduciary responsibility as board members, right? And as homeowners, holding your boards accountable to make sure that they're keeping up the common areas and maintaining the common areas. And then when something is exceeded its useful life, making sure that the board takes action to fix it instead of like chaining the tennis court shut because the tennis court has major cracks and it's dangerous to play on it. Sometimes we'll see associations just chain it shut and say, oh, this amenity is not going to be used anymore, when really that's something that an owner could sue the association's board for, because there's an expectation that I bought my unit or I bought my lot and there was a tennis court here and this should be maintained. This should be resurfaced every 6 years or whatever. And chaining it shut is not acceptable. Okay, so let's talk a little bit about the board's fiduciary responsibility. Remember, in Arizona, we have a fiduciary duty to a duty of care, which means to act in the best interests of the association, make decisions that are going to benefit the association. We have a duty of confidentiality, and then we have a duty to avoid conflicts of interest. Kind of the one that applies here is, remember that we have a fiduciary duty to always act in the best interest of the association when we're making our decisions as a board member. And as part of that, that would be keeping the amenities in good condition, maintaining them, and then replacing them when they get to a point that their useful life is over. So how do we plan a large capital improvement? First, I would definitely talk with your attorney, your management company if you have one, your reserve specialist if you've brought in a reserve company to help you with a reserve study to kind of outline, okay, what is the need here and how are we going to fund it? Do we need a board membership in order to pay for it? Do we need to get a loan? Do our documents allow a loan? There's a lot of different pivots that are needed here once we say, okay, this year we are going to redo the clubhouse. Sometimes there's a weird provision in your documents that'll say, anytime the board is going to expend over a certain amount of money, like it could be 10,000 or 100,000, you require a vote of the membership. So even if you have the money in your account, you still may need to get a vote of the membership to move forward with spending 100 grand or more or whatever. So I can't stress enough the importance, as if you're at this juncture where you're levying a special assessment or you're thinking about a large capital improvement project, having what I call a preventative legal meeting with your lawyer to talk about, okay, this is what we're thinking about doing. Help me strategize in terms of what are legal concerns or what legal things should we be thinking about? Do we have the authority to do this? And can you think of anything that could be a problem as we move forward on this so that we can anticipate any potential legal challenges that might come into place? And so you may be doing it, like I said, on a project by project basis, or you may be doing a plan over a certain period of time. But planning and doing a needs assessment and consulting with your trusted advisors is very, very important as you're navigating the planning of your long-term capital improvement project. Let's talk a little bit about budgeting and financing for these projects. So again, it's kind of like we talked a little bit about the special assessment. This kind of goes hand in hand with it. We're going to want to identify the total project cost. You're going to want to have 3 bids. You're going to want to use licensed and bonded contractors. We talked a little bit about the contingency. Having that contingency in there is really smart in case there's a problem. I don't think I've ever seen a long-term capital improvement project that didn't have some surprises, meaning like you're re-roofing. And as you're starting the re-roofing project, you start to notice that the fascia that's adjacent to the roofing is rotted and we have to replace that as part of the roofing project. That's going to add a cost to it. Having that contingency in, the whole plan and then doing a special assessment or whatever funding you're using to pay for it, having that contingency built in there is really smart because trust me, you don't want to go back and ask for more money after the fact. People don't like that. There's different funding options. We've talked a little bit about this already in this presentation. You can pay for it out of our existing money, get a loan, special assessment. You can plan it over time and just increase the assessment rate, the monthly assessment rate or the quarterly assessment rate, and then be putting money aside each time pursuant to your reserve study so that you're saving over a period of time. And then at the end of the useful life pursuant to the reserve study, you have the money in your account to pay for it. Engaging your professional team to help you. So your trusted advisors. This is really important. The team members that you may need to consider having are going to be, we talked about the attorney, right? That's numero uno. Having an engineer or an architect helping you depending on the scope and size of the project. Maybe you need to bring in a project manager because if you're self-managed board or maybe you have a management company and they don't have expertise and you're doing a roofing project that's going to cost $1 million, you want to have somebody who you're hiring to manage the contractor and make sure that they're doing the project correctly. So maybe consider having a project manager to help you. The project manager works for the association and they are overseeing the vendor to make sure that the vendor is doing everything properly. You want to have competitive bids, the bidding process. Please stay away from hiring family, friends, close associates. Never a good idea to bid out a project like this to somebody. It could also be considered self-dealing, which would be a breach of fiduciary duty. Our firm always advises against doing that. Bring in somebody who is independent, who's qualified, and get 3 competitive bids. Be careful of the low bid syndrome. Okay, this is something that we see a lot. So boards will say, we're going to go with the lowest bid, and it's usually like way lower, like 30% lower. In my experience, I found that the low bid is usually not the best bid to take because either they do a bunch of change orders and then it ends up costing you more, or the low bidder, they don't do quality work. They don't have a good team of individuals who are working for the company and they're putting on a new roof and they're not doing all the steps that they need to keep that roof from having water penetrate the roof. So be careful, low bid syndrome. Also, if you're entering into a contract, and that's kind of the next thing. So once you're hiring a vendor, have your attorney look at the contract, make sure it's not written one-sided way in favor of the contractor. You're going to want that contract to have a detailed scope of work, right? Timelines. Maybe even you put in some incentives for them to finish it quicker. They get paid a little more if they finish it by X date. Have a payment schedule that's tied to the progress of moving forward. So you're not just giving them a bunch of money because they could just walk away from the job. Check their insurance and bonding and make sure that they provide you evidence of it. Consider whether we need to be an additional insured under their insurance. Have dispute resolution clauses in there. So how do we handle a dispute? How do we terminate the contract if we're not happy with the work that's being done? We'll also want to check the contractor's references, verify their contractor's license with the Arizona Register of Contractors. You can do that all online. We're going to want to get proof of insurance, like I said, and then we're going to want to check references for projects that are similar to ours. I also typically, on top of this, have your attorney review the contract to make sure that it's not too one-sided. One of the things I do is I check to see, hey, is this contractor being sued by anybody else? Like, are there a bunch of lawsuits against this contractor? Is this contractor in bankruptcy? I read the online reviews and then I report back to the board. Here's, my comments on the contract, but also here's some other information that I found that might be useful for you as you make your decision. You may want to have a performance bond to make sure that the work gets done for larger projects, and all of that will be discussed as you're negotiating the contract with the vendor. Last few parts on large capital improvement projects having good communication with your owners and being transparent about the process is really important to move the project forward. Actually, it's probably the most important thing at the beginning because people get anxious when they see change and they get anxious when they see that, hey, I may have to pay more. And so really keeping owners informed from the start is a really good idea. So make sure that you're announcing the project, the purpose, the scope, and how much it's going to cost. And make sure that you're saying, if anyone needs a payment plan, we'll be willing to work with you. And we're going to be reasonable in terms of when the payment schedule is going to be due. And give timelines. This is when the project's going to start. This is when it's going to end. Host some virtual town hall meetings so that you can answer questions. And this should all be at the beginning of the process and maybe even throughout the process to keep people's anxiety in check and to let them know that, hey, we're over communicating to you on this. One of the things that I always say to clients is the clients that communicate the most, guess what? The HOAs that communicate the most, they have the fewest problems. So staying in touch with your owners, being transparent, listening to any concerns they have, and coming up with reasonable responses are all really important to make sure that this project is successful. Then another important aspect of the large capital improvement projects is having oversight and project management. So let's face it, as board members, myself included, I don't have a lot of construction experience. Okay. So if you want me as a volunteer board member to be in charge of the re-landscaping of our entire association, I don't have the expertise to do that. And so think about hiring an independent project manager if it's a large project to oversee the project. And that person needs to have experience. Maybe it's an engineer. And we have a list of different resources for you on that can help your association if you're navigating a re-roofing project or an asphalt project. Most of the time for smaller projects, a board person, somebody on the board can kind of be the point guard for it. But on larger projects where we can't afford to have something go wrong, spending the money to bring in an independent project manager is a really smart idea. And we'll limit your hassles and we'll just make the entire project run more smoothly. Completion. Now we're at the kind of the end of the project. After we've gotten through the entire project, everybody should be thrilled with the results. Maybe consider having a party for your community. I know we did that at our community. We had like a community-wide event to celebrate the new amenities. Also, as part of that final step with the contractor, do a walkthrough, make sure that they've done everything they're supposed to do. Ask them to release any liens that may be on the property. There are pre-liens that are done typically at the beginning of a big contracting project. And, invite the contractor to the celebration. Sometimes the contractor pays for it if it's a big enough project. Make sure that you get the warranties in writing. That should be done at the beginning of the project, but make sure that you go over any warranties at that point with the contractor. And any final approvals that we may need with the city, town, or county, all those should be checked at the end of the project to make sure that we've complied with all aspects of any county, state, or federal laws. Okay, really, that's it for our topic today. We kind of covered a lot in an hour and 4 minutes. Basically, regular assessments, special assessments, and large capital improvement projects, how to best manage those. We're going to go right into our questions. Gosh, we have a lot of questions today, 29 questions. We are going to have to move through these. Okay, the first one is, what is the statute of limitations to retain both paper documents and emails relating to HOA business, either as a board member or as a homeowner? Is there a statute? What is the Arizona statute number? So really, there is no statute specifically on like how long we have to keep the records. We have a cheat sheet on this that I would really recommend that you take a peek at. It's called records retention. You can find it on our website at mulcahy.com. Next question, are CC&Rs and ARC guidelines prohibit anything visible from neighboring property? Yet the board and ARC keep wavering on approving permanent home lighting and now plan to install it on the owner's clubhouse. These lights are very bright, flashy, and clearly visible. How can this be approved under the visible from neighboring property rule? What are your thoughts on this? I think you're kind of balancing here. Like we have to have lighting because we don't want to have an area that's not illuminated where people can trip or fall. So it's kind of hard for me to comment on this because I don't really know, is it a nuisance, the lights, or is it actually just practical? We need to have lights. It sounds like your board wants to install lighting on the clubhouse. Seems reasonable to me. You may want to go to the board meeting and find out more. Maybe if they're too bright, and you're saying they're flashing, maybe there needs to be a discussion. If you live across the street and it's not a pleasant experience for you to look at them, maybe they can tone it down with a little bit lower wattage. But my advice would be have good communication with your board. Talk it through and express to them your concerns and see if you guys can work something out. Okay, next question from a board member, number 3. Does ARS 33-1804 apply to HOA boards and committees? This is in the Planned Communities Act, 33-1804. It's the open meeting law. So yes, it does apply to HOA boards and it applies to committees to the extent that they have regularly scheduled committee meetings. Question number 4, must the chair of a board meeting be present at the meeting in person? Can they act as a chair via teleconference or video conference? So short answer on that is yes, they can act as a chair. If they're on video conference or teleconference, that's fine. You don't have to be there in person under the law. Number 5, what do you know about co-ops? Can it be converted to an HOA? So we don't have a lot of co-ops in Arizona. A handful, really, like definitely less than 50. It's a different structure. It's kind of like almost like an apartment type structure where it's different than an HOA or a condominium. Can it be converted to an HOA or a condo? It would be very difficult to do it. I'm not saying that it can't. It'd be kind of similar to like a apartment to condo conversion, but it's going to be messy and it's going to be expensive to do that. Okay, next question, number 6. Regarding violation letters. Currently, we send out a violation notice with letter 1 and give the homeowners 21 days to correct things. Next letter, per board rules established in 2015, says letter number 2 is a $25 fine. What is the best practice that fits state laws regarding violation letters? Letter number 1, notice. Letter number 2, a reminder. And letter number 3 is the fine. Thank you. Okay, so we have a great cheat sheet on enforcement that I would really encourage you to take a look at. It kind of outlines what our process typically is for violations. The key thing on violation letters is you got to set up the fine right. So typically we send a violation letter, we send a courtesy one first just to be nice. Hey, you may have forgotten, but your landscaping in your yard is in serious need of maintenance. Friendly one. Then the second one, it amps it up a little, like you have a certain number of days to get your landscaping looking nicer. And then maybe we threaten a fine there. Under Arizona law, remember, most important thing on fines is you have to set it up right. Got to give them notice of the violation, an opportunity to be heard, which could be send in a letter, send an email, come to our board meeting, and then you levy the fine after the opportunity to be heard. That's the key thing under Arizona law that you really need to dial in on. So notice of the violation, opportunity to be heard, and then you can levy the fine or not levy the fine based upon what feedback you get or whether or not the violation has been corrected. Okay, next question, number 7. When should an HOA resort to levying a special assessment? In my opinion, they should only be used in dire circumstances, such as normal financing or budgeting planning could not be predicted. I mean, there is no hard and fast rule as to when to use a special assessment. You just have to look at the totality of the facts that you have in front of you. Like, you've got a serious problem. It needs to be addressed by your community. We don't have any money in our account. You have to balance the need to have something fixed versus the financial side of this. And so I'm not saying it should only be in dire circumstances. I'm just saying you got to look at the totality of the circumstances after talking with your lawyer and your management company and think about what's best for the community so that the board is adhering to their fiduciary responsibilities. Okay, question number 8, regarding elections. What is the distinction between a power of attorney and a proxy? Does a power of attorney make a person eligible for election to the board? So a couple things. Proxies are no longer allowed in Arizona unless you're under developer control. So that's out. What you do use is a mail-in ballot. Only the owner can vote the mail-in ballot. So it can't be a power of attorney, cannot vote the mail-in ballot for that lot or unit. Also, a power of attorney, although you may be able to sell the property under a power of attorney, you can't serve on the board and you can't vote for the association. So power of attorney doesn't mean really anything in an association context. Owner votes. Owner is the person that can be on the board. Okay, next question. Number 9, can you split a capital improvement between operating funds and reserve funds? There is nothing in the CC&Rs regarding this. Okay, great question. Yes, we talked a little bit about this before when I talked about layering. So if you have a capital improvement project, it really should be paid out of the reserve fund. truthfully. Some associations don't have a reserve fund, so they have to pay it out of the capital improvement fund. But an association best practices would be you have a capital fund, which would be like your reserve fund, and then you have an operating fund, which is how you pay your month-to-month bills. I guess, can you split it? I'm not sure what you mean by that, but a lot of times we take money out of the operating fund each month to fund the reserve. So I guess it's that way. But remember, if you're taking money out of your operating fund, you did your budget based upon your needs to pay your operating expenses. You may have a shortfall and you're paying your bills in the operating side if you're robbing Peter to pay Paul. So be careful on that. Okay, question number 10. What can be done if the association no longer has, or say they don't have, an unedited version of an open board meeting? They don't have it. They don't have it. Not much you can do there. It's hopefully they're being truthful, but they don't have it. I suppose you could go to the ADRE and file a complaint against them and have an administrative law judge say, hey, you were supposed to keep that unedited version for 6 months. But I mean, if it's a pattern or you think they're being deceitful, maybe that's something you want to do, but probably not much you can do. Look at the minutes. Those would be a good indicator of what happened at that meeting. Okay, question number 11. Will ARS 33-1255 permit an HOA to make electronic statement delivery the default and then requires to opt in to mailed statements? This is a law that was passed several years ago. I really do not like this law because it does make it a requirement that we have to provide a statement to everybody regarding what the assessment rate is, whether it's monthly or quarterly. It really is a hassle for many associations and an added expense. So the question is, will it permit an HOA to make electronic statement delivery? Well, really only if the owners opt into that, because under this section, let's see what it says here. My office is amazing. They put the statute right in here for me to help me answer this question. And let's see. Honestly, this is kind of one that might be one that you may need to call me at the office or email me this one separately. But I think the way that we read the law previously was that the association is required to provide it to the owners. And most owners have opted into electronic statement, and that's how most associations are doing it. So they just email it to you just to show how much money is owed by the owner to the association. Okay, question 12. Does making a single payment or any partial payment reset the foreclosure clock, or must it be the full amount? And are boards or management free to negotiate with the homeowners? So it really depends. So under the new law, so this is going to be for planned communities. So if an owner makes a partial payment, let's say that we can't foreclose until it's $10,000 and maybe they owe $11,000 and they make partial payments and now they only owe $8,000. We have to look at it on a case by case basis, because if you're a planned community, we have to see, are they 18 months delinquent or do they owe $10,000? There's a lot of strategy going on with some of these homeowners so that they don't get foreclosed on. We just need to look at, okay, do they still qualify for foreclosure? And if they don't, we can't. If they do, we move forward. Are boards or management free to negotiate with owners? My only caveat on that would be yes. If it's with the attorney, though, let the attorney handle it, because that could be seen as a way to undermine the attorney, and we don't want that. We want the owner to pay, and you hired us to help you collect the debt. Don't go around us if it's with the attorney. If it's not yet with the attorney, yes, of course, try to negotiate always with the owners to get them to pay, even if it's a payment plan or whatever. Question 13, our community voted and we now retain the right to mandate no overnight street parking. Homeowners say it isn't their vehicle, so we have to pull tags at a cost of $35 per pull to find out who the owner is. If determined the vehicle was indeed theirs, can we charge back the $35 in addition to the fine? I don't think that you can do that. That's just going to be a cost of doing business. Recognize, though, that if you charge them a $50 fine, that kind of covers the $35 cost. Okay, question 14. We had a $6,000 pool motor replaced. Are we required to move cash from the reserve to the operating cash account? We currently have enough funds in the operating cash account. This is probably a good question for your CPA, but the pool motor likely is going to be, and it was a replacement, so it's probably going to be a capital improvement thing. Check your reserve to see if it's listed as part of the reserve. Maybe it's considered an operating expense. If you have enough funds in the operating cash, I think most associations would just pay that out of operating cash funds. Next question, 15. I'm a member of 2 associations where the treasurers appear to use the reserve funds like a piggy bank to cover unbudgeted annual expenses like winter overseeding What recourse does a homeowner have to curtail this activity? I would write a letter to the board just expressing your concerns, and I'd consider running for the board yourself. I don't know if this is going to rise to the level of removing the board, but you have the right to remove the board if you follow the procedures under Arizona law. I suppose you could go to the ADRE, you could hire a lawyer to write a letter, you could file a lawsuit. These are all different options that you would have. Okay, question 16. Do you have any thoughts on the recent news on Western Alliance Bank, with Alliance Bank specializing in HOA banking? Okay, so my office provided a little background for me. Apparently, there's concern due to risk issues. I'm not saying this is just what we found on the internet. I think the key thing is your bank FDIC insured? That should be your first pivot. Yes. You should not have more money in there than the insurance provides coverage for, right? Whatever the FDIC limit is, you should not be having more money in there, because then it's under, you don't have insurance for anything that's over the FDIC insurance amount. So yes, of course, you want to keep an eye on that. And you want to have your money be in a bank that is FDIC insured, and you want to be under the limits that the FDIC insured bank is. So that if, in the event that the bank folds, I'm not saying that that's going to happen here. I'm not in any way saying that. It's not my opinion. But you'll have the insurance with the federal government for the amount of the deposit. And we've seen this in our industry. I've been around a long time. So 29 years, I've seen a couple banks fold. And as long as you have, the money under the FDIC insurance limits, you'll be fine. And the bank's FDIC insured, of course, you'll be fine. Okay, question 17. We had a special assessment for an insurance policy 2024-25 policy year. The accounting department did not use the funds collected that were sitting in a special account for this purpose to pay the premium. It should have zeroed on July 25th, but has a balance. Now the board plans to just use this for the 25-26 policy year. With months January to July closing short, wouldn't doing so obstruct the actual status of the year closing? If the funds weren't used for the purpose imposed, can the board just reclassify the money? Lots of problems with this question. You really shouldn't be using a special assessment typically to pay your insurance premium, unless your documents would allow for that. And most documents I've seen probably would not allow for that. This is a question for your CPA. Run this by the CPA for the association. I don't know. Oftentimes something is put in the budget as a line item. We don't spend it for that purpose. So I don't know, maybe it can be done, maybe not. Question 18. We are in Mesa and have a group home in our community that gets upwards of 100 plus police calls per year. It's a nuisance with emergency vehicles blocking the street all the time. Do we have any legal recourse to deal with this? So check out our cheat sheet on federal laws. We talk about group homes and how they are an exemption under the Fair Housing Act, and associations have to allow them. But we don't have to allow bad behavior in a group home. So this clearly falls under that category. What I would recommend is that you contact our firm, and we will contact the owner of that group home and let them know that, hey, there's going to be fines. There's going to be potentially a lawsuit to stop this nuisance from occurring in our neighborhood, and go legal on this owner right now. And that behavior should stop if we do that. Okay, question number 19. It looks like we have 29 questions total. So 19, special assessment payment plan. Can you charge interest? Is the HOA acting as the lender? So I would not charge interest. I think it's an administrative nightmare, and I'm not sure that you can charge more for doing this. You could charge a late fee if they're not paying it on time. And I would not, you're not a lender. We're not in the business of lending as a HOA, but payment plans are something that's pretty common for special assessments. And you just build the late fee right into it and just have to pay the late fee if they don't pay it on time. Question 20, our HOA just passed a retroactive dues assessment of 5% back to the beginning of the year. We became a homeowner in April. Do we have to pay the 5% increase for January to March? It's hard for me to answer this question without knowing more, but I've never heard of a retroactive dues assessment increase going backwards. Very odd. But of course, you're not going to have to pay it for the time that you were not the owner. That whole thing does not sound legally correct. So you may want to reach out to us. I don't think you can go back retroactively. You may have a claim against the person you bought the home from or the condo from, but that whole proposition, I've never even heard of somebody trying to do that. And I don't think that is even legal. So I'd have to hear more about it. Okay, question 21. Our HOA is planning a special assessment vote. After reviewing the CC&Rs, we learned that one major repair item is actually the homeowner's responsibility, not the HOA's. However, since the 1970s, our HOA has maintained this, even though it was the owner's responsibility. Now the boards reversed their position, requiring homeowners to pay for the costly repairs resulting from years of deferred maintenance. Do homeowners have any recourse? Well, if the CC&Rs say it was their responsibility and the board gratuitously may have made repairs for it, I still think the document says that it's the homeowner's responsibility. So likely the homeowners are going to have to pay for the expense to repair whatever this issue is. Question 22, thoughts on a structured bridger financing, vehicles versus large special assessments, large scale capital projects in terms of supplemental to adequate reserve funds. Okay, so structured bridger financing, vehicles versus large special assessments. Okay, so I'm assuming you're meaning like a loan, where the bank gives you like a quick loan to help you bridge the gap until you can get the money, or maybe you're just doing a loan just to pay for it. It's pretty common. It has to be in your CC&Rs for you to do that. Definitely get legal counsel involved to help you navigate that. We don't see associations taking out loans that often, but I at least have a couple a quarter that we are helping associations navigate. Question 23, our master association consists of 6 separate entities. The master has not held any meetings or taken any action for over 10 years. When the master association eventually holds a meeting, would that meeting be open to all homeowners? Very odd that they're not conducting meetings. They should be under Arizona law. It should be an open meeting. Of course, if it's considered a planned community, they are subject to the open meeting law and they should be having regularly scheduled open board meetings. Question 24, a board now schedules a regular board meeting every other month. Is that action in the best interest of the members? I don't know. Maybe you don't have enough business to have a meeting every month. You may want to ask, hey, why did you go to bi-monthly? Do your documents require a monthly meeting and they're violating that by going to every other month? I'd be interested to hear what they have to say. I do have some boards that work on a quarterly basis. Some do it every other month. Most do it every month. So I would just open the lines of communication with your board. Okay, question number 25. Does exterior painting of the units qualify as a capital project? It depends. Usually it is a reserved item on the reserve. So, usually it could be considered as a capital improvement project. Okay, next question. 26. Our community is labeled underfunded and not approved by the FHA, Fair Housing Act, with several major capital projects pending. Will banks consider lending to an HOA in this situation for a construction loan to fund repairs and offer homeowner payment plans? Okay, so you got a lot going on in this question. So different things mean different things. So FHA, if you're not approved by FHA, that just means that your owners can't get loans through government, through Fannie Mae or Freddie Mac. And that happens sometimes when the association doesn't have an adequate reserve or when an association has a lot of rentals. That's a separate issue. So that means your homeowners can't get loans from the federal government to purchase or refinance. That doesn't mean that an association can't get a loan. Typically, an association is going to go to a private bank, not to the government, to get a loan. And in my experience, I don't think I've ever seen a bank say no to giving a loan to an HOA. If we had the right to do it under the documents and we have a way to pay it back, I don't think that's going to directly impact the association's ability to get a loan. Question number 27. What should happen to the contingency fund if you don't spend some or all of it? Can you put it in the reserve? That's a great question. Okay, here's what you need to do. When you do the special assessment, you say that if there's any money left over at the end of the project, that money will be transferred into the reserve account. So that should just be written right into the vote on the special assessment. I agree to a special assessment of $10,000 per owner. Any money that may be left over, and then say what it's for, obviously in the vote, and then have a sentence in there that says any money that's left over will be transferred into the reserve account. Perfect way to handle it. Next question, what steps are needed so that our community can begin the process of leaving the master association? You need a meeting with our firm. Very difficult to leave the master association, just so you know. You have to look at the documents. It's probably impossible, but you may want to reach out to your legal counsel to talk about that. Okay, next question, 29. Our HOA transferred funds for a capital improvement project to a new 501c3 nonprofit. but the details and future obligations are unclear. Are there legal precedents for using a third-party nonprofit to handle HOA projects and bypass member involvement? I really don't see this very often. Sometimes, like, there's a donation from an owner to fund a project, but this is very unusual. So I would say this is not something that I see very often, like maybe twice in my 29-year career. So this is definitely something I would be asking some questions on. Okay, question number 30. Let's see how many. We got 3 more questions and then we're done. Okay, many neighborhoods oppose group homes, sometimes out of fear rather than facts. Since group homes are a protected class, where can we find information on protecting their residents and owners? When does state or federal law override CC&Rs, and can boards impose small business restrictions to avoid these protections? So check out our cheat sheet on federal laws, because we give a really good overview of how group homes are a protected class and how group homes should be allowed as long as they meet the requirements set up under the Fair Housing Act, and how associations really can't do much other than treat them just like any other owner. And if they're making violations, we can treat them like any other owner and fine them or file a lawsuit against the owner or whatever. Where can we find information on protecting their residents and owners? I'm not sure what you mean by that. Oh, so I think maybe you're looking at it on the side of the owners of the group homes. The Fair Housing Act, obviously, the Attorney General's office would be where you first stop if you feel like you're being discriminated against by an association. This is definitely a federal law that overrides the CC&Rs, because group home is a business, and most association documents have a prohibition against running a business out of your home if it meets certain requirements. But this is a federal law that trumps our documents, and check out our cheat sheet on this. It's something that we have to allow. Okay, next question, 31. When is the perfect time to plant the seed to our homeowners that we are planning a special assessment? How many months ahead of time before an owner vote? I would say as soon as possible so people can start planning. What you don't want to do is shock and awe them with like, oh, we're having a special assessment of $5,000 due next month. That's not going to be good. You probably want to set that up over a 9 to 12 month period so people can start planning. Okay, question number 32, last question for today. If the community uses their reserve funds for a large project and then the reserve study is under 50% funded, and the allowed 10% annual increase in assessments is very unpopular with members, what is the board to do? Deplete reserve funds can limit people's ability to get a mortgage. This is a great question. I don't have the answer for this. It's healthy. Try to have your reserve study in that 50 to 80% funded range. These are tough decisions. Unfortunately, when you serve on the board, you have to make the tough decisions. How do we pay for it? Do we increase the assessment every year by 10%? Do we do a special assessment? Do we have to take out a loan? Are we going to deplete our reserve fund, to pay for this and try to build it back up over time? These are all things that you should get advice from your trusted advisors, from your attorney, your reserve specialist, your CPA, your management company, so that we can help you make the best possible decision for your association. Okay, wow, we had a great day today. We got through a lot in an hour and a half. So we had over 219 viewers on Zoom and Facebook Live. So amazing turnout today. Thank you so much for being here today and caring about your community. We have a couple more opportunities in 2000 for you to listen in and get free legal advice. Our next First Friday is Friday, November 7th. That's where you can join us on Zoom or Facebook Live and have one question answered for free. And that's going to be from 9 a.m. to 10 a.m. on Friday, November 7th. You can find out information about that on our website. We also are going to be teaching a class for Surprise, City of Surprise. It's going to be called the Surprise HOA Summit. It's going to be on Tuesday, November 12th from 6 o'clock to 8 p.m. It's going to be a hybrid format. It's not limited to only Surprise owners, people who live in Surprise. It can be from anywhere. We're going to be talking about new legislation, what are responsibilities of board members, and how an owner can make positive change in their HOA or condo. So check out our website on that to get more information, find out how to register. And last but not least, we have our November class, which is class number 11 of our Neighborhood Services HOA Virtual Academy. That's going to be November 18th at 11 a.m. Look forward to seeing you at future classes. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.